Hi, everyone. Thanks for joining us today. We're running just a couple of minutes late as we're trying to work out some technical difficulties with our other panelists. But in the meantime, I wanted to get us started. So hopefully it will work itself out in a couple minutes. This is NAVI's final 2025 back to school program. It's been a really great fall. This one's Parent Power, Know Your Rights. We're presenting it by NAVI in collaboration with the StandWithUs K-12 Fairness Center. We do want to thank David Smokler, who is the executive director of the K-12 Fairness Center, for collaborating with us on this program. Over the past few weeks, for those of you that have joined us with all our programs, we've shared insights about countering activism in the classroom, teaching critical thinking through viewpoint diversity, and depoliticizing curriculum. In today's program, I'm really excited about because it sort of brings everything together with some legal experts that can sort of help us unpack and understand some of the important elements of the law as it applies to those topics. And wonderful, our panelists are all here. So I will quickly introduce myself and our panelists, and then we can jump right in. I'm Sharon Sorkin. I'm the mom of 2 middle schoolers in Ann Arbor Public Schools. I recently joined NAVI as Director of Community Engagement. But for the past 20 years, I've been a practicing trademark attorney with multinational companies. So that means I know only enough to be dangerous in the educational law space, which is why I've invited 2 educational law experts to help us understand things. So first we have Jenna Statfeld Harris. Jenna is senior counsel with StandWithUs Saidoff Law. She focuses primarily on addressing antisemitism in K-12 schools. Prior to joining StandWithUs, she worked as a senior attorney in the Economic Justice Unit of Bay Area Legal Aid. She also previously worked as a tax attorney at a large law firm, focusing on corporate and promoter clients. As a law school graduate, Jenna was a Skadden Fellow at the Education Law Center, where she specialized in special education, bullying, and discipline in public schools. She graduated from Harvard Law School and the University of Pennsylvania. And we have Jen Deutch. Jen is a seasoned educational lawyer in the Chicagoland area. Before her current position, she taught in a variety of educational settings, including a psychiatric ward, therapeutic day school, and traditional public school. She proudly served as legal counsel for the U.S. Coast Guard. She's passionate about serving the educational community and was recently awarded the Charter Count Award by the City of Highland Park, Illinois, for her commitment to community. So thank you both for being here. I'm just going to do a couple of housekeeping points before we jump right in. So one, because we're all lawyers here, we have to say things like this doesn't substitute for legal advice. So you're all here to hear some key points and understand some suggestions of how to approach these things. But we don't suggest that you take the law into your own hands. You should definitely consult an attorney if you think you have a legal issue. Of course, the attorneys here are happy to help, and we can also refer you to other experienced attorneys in this area. So we won't be able to answer any fact-specific questions. So if you put into the chat, this happened to my child or whatever, we'll refer you out. But if you want to ask some general questions, we will definitely take those in the comments. So please add them there, and I'll try to get to as many as possible. After the presentation, we'll also be circulating a Know Your Rights parent primer. So look out for that coming soon. Before I dive in, Jenna or Jen, is there anything you'd like to share that I missed as we sort of jump into this important topic?
Thank you for having us. Really excited to be here. Jen, unmute yourself so that you can talk over me whenever you want to.
Perfect. So the first thing I'll say is, as we go through this conversation, many of us parents are hearing some of these legal terms for the first time. And we're sort of, it's all kind of needing to be demystified for us. So as we dive in, and I know you both have some slides, we'll kind of use those to guide the conversation so we can dig deeper on some of those terms like Title VI and OCR and discrimination, all these things that we hear, First Amendment, they'll be thrown around, and they are certainly thrown around when we're trying to advocate for our kids. And so it always feels good to kind of have a better understanding. So I mentioned First Amendment. I hear a lot from parents that are concerned about activism in the classroom. They might hear about a teacher that shared a personal political view, maybe worn a shirt or a piece of clothing that makes a political statement and maybe makes a student feel uncomfortable if they don't share that opinion. Maybe the teacher is participating in walkouts. Maybe they're posting things on social media and they're friends with their students. I mean, there's a whole host of things. Now, I know enough to know that this is First Amendment related, but I don't really know how to unpack and think about some of those things. And we hear that both about teachers and school board members. So I'm just going to open it up to you guys. I know that there's a lot, and I know you're going to say, well, it depends, because that's what we all say as lawyers. But I'd love to hear just some of the things we should think about as parents.
Yeah, absolutely. Jen, before we start the First Amendment, I just wanted to do a quick to take a step back about just explaining to the people that we're speaking with about our job versus your job as parents, if that's okay.
Absolutely.
So I would love, Sharon, I think if we show, oh, thank you,
Beautiful.
Okay, so just very briefly, we want to give you all as much information as we can so that you feel really empowered. But what we don't want to do is make you feel like you have to figure all this out on your own. So we will talk about a lot of different, like Sharon said, a bunch of legal jargon, a bunch of laws, a bunch of policies, and all kinds of tips. Please keep in mind that our job is to get into all this. Like, if you could just, I'm sure we've all done this, right? You just Google, what is Title VI? What is my district's policy on this? Our job is to really understand every single piece of those. Your job is to have some sense of when there's a problem and when to reach out to us and how to be documenting these things as you go, so that if you need an attorney, you have all the things that you need. But please don't feel the need to become experts unless you want to go to law school and come intern for me or Jen, and then we'd be happy to have you. But don't get bogged down too much in any of these details. So that's number one. And the second is that some of this will feel a little, we do this a lot with students, but some of it can feel a little dry. The reason why we get so much into the nitty gritty is only because we know what it looks like when things get escalated. So when you are going back and forth with your district, it's important to use the right words right away, because we know, just to pull back the curtain, what the forms look like that eventually might have to get filled out. We know what the laws look like that will eventually that your evidence will get held up to. Okay. So you can sort of ignore the specifics that I'm putting up here, but the point is every school district has their own version of these forms, and don't just fill them out without speaking to one of us, without understanding a little bit more. Okay. All right. I think there's one more of these kinds of the why. The last thing that I'll say, we will talk more about Title VI and try to demystify that for all of you. One of the most important pieces of Title VI, when you're arguing that your school district has violated this federal law, is about whether or not the recipient, which is the school district, had notice. Okay, so we will explain why it's so important and how to notify your school district when you're worried about something. All right, that is all of the.
Jenna, if you can keep that slide up for 1 second.
Yeah.
If you look at that third prong, it talks about, I think, a really key term, which is a little bit newer in some of the guidance. It talks about prompt and effective. And when you're looking at OCR and you looked at the guidance that came out with respect to Title VI, the guidance was really strong about prompt and effective action by the school district. And so to sort of build off what Jenna was sharing in terms of taking good notes, it's having an understanding of what did the school district do when you made these complaints, and was it effective, right? So not just did they respond, but did we see something as a result from it, and that prompt piece. So in other areas we haven't seen, or I haven't seen, I practice within antisemitism, but I do a very global practice, bullying, Title IX. And there seems to have been, from my experience, a real push in making sure that schools are being held accountable if their action isn't both prompt and effective.
That's great. And I'm going to just press on this right now because you said it. So can you just say for everybody what the OCR is?
Yeah, so OCR is the Office of Civil Rights. It's a department under the Department of Ed. And just for context, we've all heard about various federal sort of changes that are happening. For those of you that have heard of blue ribbon schools, the Department of Ed has just taken away the blue ribbon process. So schools are no longer going to be awarded blue ribbon under the Department of Ed. So I have seen the Office of Civil Rights continue to move on these cases. And Jenna, you can reflect off of if you have any sort of difference, but it is under the Department of Ed, and they are charged with making sure that schools and agencies that receive public funds act in a way that provide equal access and that they're not discriminating.
Great, thank you.
So Title VI and going to OCR is just one of many tools that you have in your toolbox. We will get to how it all would play out. That's certainly not the first step. We can go to Sharon's original question, which was about the First Amendment, which as certainly for me as an attorney that works with parents all day long, a school district, like they'll complain to a school district about something that happened and a school district will basically just respond, our attorney said there's a First Amendment right here, there's nothing we need to do. So those attorneys are not as nuanced as Jen. So we will get into what it means, like what the First Amendment actually says and what it means for your students in a school district. Jen, so I'm going to, do you want to give your own example, Jen, or do you want to do mine?
We can do either. I'm just going to move back and say that I think that the First Amendment is a great place to start, and it is a place where school districts often respond back. But I'd like to empower the people on this call to recognize that they need to be helpful in a leader in shaping the conversation. So Sharon, one of the things you mentioned was walkouts, okay? Yes, there are some First Amendment rights to walkouts, but look at your school rules and look at your school policy. It might not just be about a walkout. So for example, in many schools, there are truancy rules and truancy policies and policies with respect to not leaving classrooms without prior permission. And so districts have looked to discipline both students and teachers for engaging in walkouts when you walk out during like a instructional period. There are journalism laws that states have. So while there are definitely First Amendment rights, and it is very clear ever since Tinker was like the first case, with respect to First Amendment, what I would encourage you to do is not stay within the boundaries necessarily of what somebody else gives you. Jenna talked about that there's a lot of policies and procedures that schools have. And so I would encourage audience members to be liberal and robust with respect to what they look for when they look to engage with schools.
And so I think we talked about things like, there might be things like dress code policies, there might be things around controversial topics in the classroom, that there are all types of policies that may sort of be working, interplaying with the kinds of things we're seeing in the classroom, like politicization or apparel that somebody might find offensive. And so I think that's kind of what you're saying, is kind of look at all of that in totality, and maybe even addressing stuff through the policy is an effective way to kind of talk to your district.
Yes, exactly.
Awesome. And I mentioned, I think where it gets a little more, I imagine, gray is, many parents come to us and say, can you believe what this teacher posted on social media? Or can you believe what this school board member posted on social media? And I think it's really complex, so probably it could be a whole session, but can you guys say a couple things about the kinds of issues that you might unpack when you're thinking about that?
Yeah. So Jen, let me just first of all, you guys can see this is something that we say all the time.
Yes.
Just because it's awful doesn't mean it's unlawful. Sometimes it's okay to be uncomfortable, right? We really have to help ourselves and our students be comfortable with that idea. Just because someone says something doesn't mean that it's against the law. So please keep that in mind, because I think we often rush when we feel unsafe or scared or triggered to use these words, these legal words, and it's not always to our advantage. I wanted to just quickly put up what the First Amendment says so that people can just read it and understand what we're actually talking about when we say the First Amendment. And then we have some specific slides that help explain that, like practically. So Jen, do you love this one? Do you want to do this?
Yeah, that sounds great. So when we talk about First Amendment issues, I think that one of the most important things is, Jenna, what you shared, which is that there are things that are uncomfortable, but they might not be unlawful. And it's important to understand how we cross that line. So like with respect to the example of social media, something changes with respect to its lawfulness depending on where it might be posted. So is it someone's personal account, or is it their public account with respect to a board member? The same thing might be said on a public account, which might make it crossing the line, but on a private account, that would be okay. And when we look at whether or not the First Amendment applies, we need to make sure that we understand that it's not just uncomfortable, but that it is actually unlawful. And within the school district setting, within the school setting, I think one of the prime factors you can look at is substantial disruption. When we're looking at First Amendment speech, the cases, the court cases over time, and both two very recent cases that came out that had nothing to do with anti-Semitism. They were a case dealing with somebody wearing a weapon on their shirt. Those cases really look at that substantial disruption piece. So what did that speech do to the instructional environment? It's important to also look at context. So what ages were the kids? Was it a high school or was it an elementary school? And what happened as a result of it? So was there a substantial disruption? Was instructional time lost? Did kids stop coming to school? Sort of looking at both the potential impact and the actual impact. What's important to recognize is that what a school can't look at is whether or not they happen to like the speech. Okay. And that's important both ways, right? So if you are in a district that is, very much supporting things, then it can't like support something because it's in line with it. So there was a case not that long ago of I think she was a mayor. And every time you spoke at an open session and you said something that was in her favor, you got to speak forever. And if you said something that wasn't in her favor, you got shot down. And the court said that is specifically not okay, right? It can't be based on whether or not we like the content.
I have sort of a follow-up. So we've seen a lot that teachers will use their personal account, but they will be friends with lots of students. So the students are seeing their content. Potentially it's impacting classroom. I imagine that it's still their personal speech, but can a school maybe tell the teachers that they can't friend the kid? Like, is there policy ways to address them just not being exposed to content?
Yeah, so many school districts have communication policies where actually teachers cannot be friends with students. And so if people are familiar with the app Remind, okay, Remind allows the texting to various groups through an organized system that like the school would control. So that doesn't come from anti-Semitism. That comes from Title IX issues related to inappropriate relationships between students and teachers. And so many schools have rules in place with respect to communication barriers so that teachers shouldn't be directly communicating either through cell phones or through texting or through social media directly between students and teachers.
That's really, really helpful.
And so,
I know you're mentioning other policies. Yeah, go ahead.
Well, and practically what that means is that if your student finds a teacher's post that is inappropriate, controversial, seems to cross some kind of line, the first thing I would recommend is to screenshot it. That in a way that shows, I'm too old to really explain this well, but I guess you can show if you're friends with the person who's posting, right? So again, like Jen said, it's not really about the content itself. It's like the teacher has broken a policy by friending this student. If the student can see it, that is a violation of a totally separate district policy. The only way to prove it is if you have that screenshot in the moment. So please like over screenshot, and then we can analyze it with you after and check the policies.
Yeah, that makes perfect sense. Do you want to dive into some of these other policies that might be involved?
Yeah. So this is supposed to say teacher speech in the classroom, but it actually should just say teacher speech because we're also talking about social media. And sorry for the tech messes here, but
that was me. I'm sorry because sorry, go ahead.
Okay, so a few things to pay attention to when teachers are speaking. Again, number one is context matters. So as Jen said, like how old are these kids? What are they talking about? Does this have anything to do with the subject matter? If you're in a math class and the teacher is talking about their personal views on a current event, that doesn't really make sense, right? And from, again, practically, students are unlikely to be able to be they should not be recording a teacher speaking in a classroom if they're not supposed to be recording a teacher speaking in a classroom. So they should just be taking some kind of notes, right? Be able to take notes afterwards, something that documents what was said. And then we can look at the policies that exist in the school. If there's a controversial issue policy, which most school districts that I've worked with have, it basically says something. So let's say it is related to the subject matter in the classroom. It's not a math class in current events. It's a world history class and they're talking about something, but it's a controversial issue. What controversial issue policies usually say is something like, if you're talking about a controversial issue and that will be defined in some way, you must provide both sides. You must provide alternative viewpoints, right? So if you're sharing something on one side, we need to know that it was balanced with the other side. If not, that's a violation of the controversial issues policy, kind of, period. It's not more complicated than that. Districts are making it a little more complicated, but it doesn't have to be, and we can help you with that. Jen, do you want to talk about dress code policy for teachers as opposed to for students?
Yeah, so I think when you look at the dress code policy, different schools have like a variation on dress code policies. And really, the dress code policies have been challenged both at the dress code policies, when you look at teachers, I think is very difficult. I'm just going to put it out there. Okay. When we talk about dress code policies related to students, we have certain areas that we can be very clear about. So certain states will have law or rules that say, like, you can't have anything related to drugs, you can't have weapons, or you can't have these particular areas. Dress code policies, when it comes to teachers, is a little bit more difficult. And I think what we need to look at is, what is that message? And is that message in violation of particular policies that are otherwise adopted by the school? But traditionally, we don't have dress code policies for staff members about modesty or gender-based or uniforms, things like that, which do apply at the student level.
Yeah. And one thing I'll add is, so NAVI is working in the background on promoting institutional neutrality with school districts. And so one of the things we think about is, obviously, teachers in their capacity as teachers are sort of speaking on behalf of a school. And so you might think about whether apparel, if it's a political statement, could be captured in neutrality, right? That it would be difficult for a teacher to show up in with a MAGA hat and then not say that they're making a political statement when the school is supposed to stay neutral. So we'll be testing that, right? It's not clear. It's not, I'm sure you guys haven't seen this stuff kind of in the law yet, but it's sort of a test case for how we might be able to sort of manage some of that in the classroom for the purpose of making it a safe place for all students of all viewpoints.
Right.
Yeah, I think we saw this for the first time. I'm sorry.
Go ahead.
Go ahead.
I think we saw this for the first time, not necessarily with respect to dress, but with respect to expression when COVID first hit. And so when COVID hit, we had everyone participating on Zoom. And so, and we saw more pins being worn, and we saw things in the background on people's Zoom. And so we started to be answering some of these questions in terms of what was allowed to be showcased by a staff member through a school-based setting. So it's not exclusively about actually what you're wearing, but also can be about like what you're presenting to the school as like your own, or to your class, in terms of like either a pin that you're wearing or a background on your Zoom or on your bulletin board, that kind of thing.
Yeah. So we actually just saw a really interesting situation happen in Evanston where a teacher was putting up artwork. I think it was, related to the Israel-Gaza conflict, and it obviously expressed a specific side. And the school district actually asked him to remove it and indicated that the school district was going to commit to a neutrality position, and that by presenting one side in the classroom, sort of would undermine that. So we were pretty happy to see Evanston do that. And we kind of hope more school districts will sort of look at it that way. And when they do introduce controversial topics, to your point, Jenna, that there are multiple perspectives, and that, it can have sort of that purpose of learning and civil discourse.
Right. And I think, again, if I may be practical, I don't think that the best response to addressing one side of a controversial issue policy is to say to them, like, shut it down, right? We don't want to talk about it. That's the ideal. Like, this is hard stuff. We want our kids to be able to engage with it, obviously in an age appropriate way. But when we're hearing that there was one side of a controversial issue presented, the first thing we should be asking for is that the other side is presented.
Yeah.
It should not be to shut down the first, right?
Yeah.
And whenever we are asking for something to be, well, we should, if we are ever asking for something to be shut down, we should understand that that will come back to us on the other side, right? And
absolutely.
so you must be comfortable with that. Again, do not figure this out on your own. We are here for you, but just be aware of all that. Okay, I think let's keep moving.
Yeah, I just really love your point, though, that academic freedom is not unlimited. So I wanted to just highlight that, because we do hear that a lot when parents complain. They say, well, we're free to teach what we want to teach. Right. That may be true in the university setting, but I understand it's more limited in the public.
Right. This is why I prefer working in K-12 than universities. Academic freedom is crazy there. It's very important. Obviously, we want our teachers to be able to feel free to say what they want. I don't know enough about what's going on in a classroom to get involved, but we do. But there are limits. It has to have something to do with the subject matter, something to do with their own expertise. Has to be appropriate for the kids. We've heard some pretty crazy stories about things that are being presented to kids. Again, it's not really about the content. It's just like, it doesn't really make sense for that to be being discussed right then and there.
And that's actually a great segue.
Sorry, when you're looking at academic freedom, I would echo very much what Jenna shared in terms of that. It's like the Wild West in the post-secondary, and there's actually lots of boundaries and standards within the K-12 arena. And depending on what state you're in, there can be an incredibly structured approach to what actually should be taught. So a number of states have state standards. So like it will say, like, in geometry, these are the particular things that should be taught. And then if you are a parent and you're saying like, oh, well, I didn't have this, then you can just go look at the state standards and say, like, does this fall within that or outside of it? And even in places where it's more difficult, like a writing class or a social studies class, I think that what you can look at is this within or with outside of that? And I think that can provide a lot of structure with respect to whether or not something should be or is appropriate to be taught in that arena. I think, though, that this issue particularly has become more complicated as our classes have become more complicated, meaning in the delivery of them. So back in the day when I went to school, I had a backpack and there was something called textbooks inside my backpack, and they were huge and heavy. For those of you who have high schoolers, if they're anything like my high schoolers, they don't have like textbooks the same way, right? They have Google links and they have articles and they're reading various books and ebooks. And so being able to like nail down what the curriculum of a classroom is very difficult. And that's a place where, to reflect back off of what Jenna shared in terms of like our job and your job, this is a place where as a parent, you can help dial down in terms of, okay, what is being taught? What is being shared? And trying to understand like what was part of that class.
Yeah, you made the segue for me, Jen. So thank you. Yeah, I was going to just sort of ask, my understanding is that there are state curricular standards. It differs kind of state by state. I was just talking yesterday that here in Michigan, we're a local, I forgot the word they used, but essentially some states have curricular mandates that come from the top, and then some of them, they give it to the districts. And so Michigan is a local governed, but some states have, like California has their ethnic studies mandate, for example. But I, like you, find it really difficult to see exactly what my middle schoolers are learning, and then kind of unpacking that. Are they learning something that actually ladders up to the curricular expectations for that class or not? And that's usually what I've said to parents when they call me and say, I can't believe my kid's reading this book. Or I say, well, start with what is English Language Arts 1, 9th grade supposed to be about? Is it even in the framework of what they're supposed to be learning? And if it's not, that's the place to have the conversation. And then if it's in there, but it still feels problematic, maybe it's a different conversation. But what if you can't even get to, like, parents want to get to the curriculum, and sometimes it's transparent and sometimes it's really hard to get to. Are there tools to get there? Like, how can you find out what they're learning?
So the first place I would look is a syllabus. So like my high schoolers all have syllabuses. So I think that's like the first easy place that's published or presented by the teacher. And it's saying like, this is what I'm going to teach. So school syllabuses are a great pathway to understanding what a class is going to teach. The next piece that's been mentioned is the state standards. So there are some states like Florida where there's like a generalized curriculum where everyone kind of has the same. And then there's states that have more variation. So we can decide on a local level. So you can look at those state standards. And then some states have laws that say, like as a community member, you would have access to curricular materials. And then you can request it through those policies or state laws.
And those are, so just to, so there's like acronyms that get thrown around also. There's something called FOIA, Freedom of Information Act, something called PRAs, Public Record Act. So depending on your state, you can make, if you can't find the information that you're looking for anywhere else, you can submit a formal request for public records. Many of these things are required to be made public to anyone in the public, but certainly for parents. And you can make that request online. You usually can Google it and find it. Come to NAVI, come to Stand With Us. We can help you do it. A few tips there. Number one is the district has a certain amount of time to get back to you and provide you with the information. They might say your request was too broad, right? And then you'll have to, and we can help you make sure that it's not too broad. They might say we were going to charge for X amount over this page number. Sometimes that's okay, sometimes it's not. To Jen's earlier point, if it's specific to content, like if they only charge parents who ask for this kind of curriculum, but not this kind of curriculum, that makes us really uncomfortable and we can step in right away. And they also, a lot of parents say, I really want it all emailed to me in one document, but they're making me come in to the office to review it. Again, as long as it's content neutral, it's okay to ask parents to come in. It can be very unwieldy and administratively costly. So don't jump when you get that response. Come check in with us. It might actually be okay, but ultimately you do have a right to these records. If the request is made in the right way, it should be granted in the right way.
Yeah, and NAVI is working on, in the background right now, some sort of FOIA key things to know. And you mentioned, and I was surprised when I learned this for the first time, that there's a cost, and depending on how broad your request is, it actually could be relatively costly. It's always. But
I really would urge, Sharon, I really would urge parents to make sure that they are not the only ones who are getting charged, because we have heard stories where certain parents are getting charged and certain aren't. Attorneys are, like, usually what I've seen is that attorney, like if I send something, they're going to ask for some amount of money. If a parent does, they might not, which is good. But we should just be making sure. And I think the districts are figuring this stuff out too, because this has become much trendier recently, and they're getting in, I'm sure Jen knows this, like they're getting inundated in a way, every time parents learn a new tool, suddenly asked a lot more of it.
And I will say, I mean, my experience too is because of FOIA or Right to Know or whatever it's called, teachers, administrators, board members are very reluctant to send emails, and they avoid putting things in writing, which I suppose if I'm their lawyer, and Jen, I know you work with school districts, it's probably wise. However, it can be kind of frustrating. So what we've been saying is, when you have a conversation, maybe send an email back and say, this is the conversation we had. Correct me if I'm wrong. Here's what I heard you say. And so at least it's in the public records and it's in writing.
Sharon, there was at Stand With Us, we brought a Title VI complaint against the school district based on we had submitted a big public records request. We had access to all kinds of emails that were going back and forth between teachers and administrators and parents that did not look great for the school district. And so they actually, the Title VI is still pending, but the school district has really tried to introduce a bunch of new great initiatives to respond to some of our concerns, not all of them. But one of the things that they accidentally did was that the superintendent advised her staff in writing to stop because it's subject to public records requests. So yes, we're all learning.
Yeah. So she put in public records, don't put anything in public records. Lovely. Yeah. So, but I was surprised, and it made sense to me. Like almost every time I'd send an email to my principal, she would immediately call me, and I was like, oh, that's why. Yeah. So it's a great tip to just follow up with an email, even if it's a phone call or an in-person meeting.
I wanted to, we do one more. I think
Yeah.
that we covered the board members, but I think we had said a few things without
Beautiful. Yeah.
breaking it down. I'm sorry, hold on one second. Oh, this is Tinker. I think we did this. Hold on. Board member speech. The only thing, because Jen mentioned something really early on, I just wanted to, this
is where the board member piece comes up, is like, where is the speech taking place? Is that where you're at?
Yeah, just sort of like explaining a little bit more, like what can a board member say and where. I mean, it doesn't just have to be social media, but that's often where we're seeing it. What's worth getting upset and complaining about, and what's worth dropping? Jen, do you want to touch on that a little?
Yeah, I mean, I think what's important to understand is that a board member doesn't necessarily like lose their right to demonstrate public concern. And there is a balancing test in terms of how that looks. And where it happens is also really important. So I think one of the easiest ones where we see like complaints is if a board member will shut off comments. And if a board member shuts off comments on their public page, that would not be okay. But if they shut off comments on their personal page, that would likely be okay. And really what it has to do with is the silencing of discourse and discussion. So if you think about public page, it's kind of like a public forum. And so you couldn't just say to somebody like, stop talking, I don't like what you're saying during public comment of a meeting. And so that same would apply to public official turning off their comments. We're talking about board members here, but teachers are also public employees, right? And so their speech is often can be monitored if it comes through them as a teacher, as opposed to them in their personal capacity. So I think it's the first thing that I would look at, and reflecting off Jenna said, like talking about screenshotting, is recognizing where the content is said, what it said, and who the audience is. So is it elementary school kids or is it high school kids? And then also looking at what kind of authority. The recent case that came down really looked at, did the person have the authority to speak on what they were speaking about? And did they take a stance that they have the right to speak on that? So kind of looking at those issues, and then making sure that we understand that there are certain things that can never be acceptable. And so that's that idea of inciting violence or making true threats. That really stems way beyond anti-Semitism, right? So we have issues like related to referendums, like trying to drum up more money, that have become very, very volatile, and looking at the board speech on that and threats with respect to that.
Yeah. I encountered one where we had a budget crisis in the community, and people were, commenting all over social media to the board members, and the board members were blocking people for being upset about the budget. So yeah, it happens, I think, all over the place.
Okay, then the last thing, and if you want, Sharon, we can move on to but I just wanted to close the loop on the speech piece. So there's sort of like the law, right, and the policies, and then there's just sort of what you actually should do about it and what a school district should actually do about it. So one of the things that I really try to emphasize with parents is that just because something did not cross one of those lines that Jen talked about, just because it's protected by the First Amendment, it doesn't mean that a school district can't do or say something. You might not be able to shut down that speech, but maybe they can condemn it. Maybe they can see that there's a problem going on, right? If there are so many swastikas, that's actually not a great example of being protected.
I was going to say.
Sorry. If there's so much of like, let me think. I'm trying to think of something offensive, but whatever. Think of something offensive that's protected. If there's so much of something going on, I mean, we could even just use the example of like, someone keeps writing everywhere, "I hate fat people," all over, all the time. Maybe a school district says that's technically protected by the First Amendment, but we don't love that as a value in our school. Maybe we need to do an assembly about this, right? Maybe we need to do some checking in on what's going on, checking in on our students who are being impacted. Why are students saying that, right? It's not about the First Amendment anymore. Like Jen said, that is sort of thrown out. But just because it's protected by the First Amendment, it's not the end of the conversation. That's one side of it. The other side of it is, just because it has crossed a line, I mean, except for, like if you need the police to get involved or there's a safety issue, just because it has crossed a line does not mean that you should automatically send the angriest possible email or social media post calling something unlawful and calling the school district a bunch of whatevers. There are different options there. So being measured on both sides of this is really important if you're trying to work with your school district.
Yeah.
Yeah, and I would go back to the curriculum on that one too, right? So for example, like I had a number of situations where I heard about where after the recent shooting, a lot of social studies classrooms, they might have been like an ancient history social studies classroom or a classroom that was talking about medieval history. But those teachers stopped for a minute to talk about violence in America or to talk about sort of what does it mean to have somebody shot for their political beliefs. And so I think that hopefully we can recognize, well, that doesn't align with the state standards of that particular classroom. You have a teacher that took a very poignant moment of history in a social studies class, deferred from the general curriculum to talk with their students about it. Now, depending on what they said about it, it might be appropriate or inappropriate, but I don't think like the momentary deferral from your state standards is necessarily something that we want to file a complaint about. Okay. So I think it's looking at two key terms that I really like to look at are the severe and pervasiveness. How severe is it and how pervasive is it? So Jenna's example of calling someone, lots of fat comments. Okay. That would be something that would be great for a character counts discussion or an anti-bullying discussion, talking about PBIS, talking about making sure that we have, safe schools. So all of those really fall in line with our school social and emotional curriculum and making sure that all students feel accepted.
I think that's great. And I think maybe this is a nice segue. I'm kind of going out of order to talk a little bit more about Title VI. And I know part of what's in there is potentially creating a hostile learning environment being something that might come up. So maybe we could jump there and then we'll go to our practical steps after we do that.
Okay, so sorry, everybody. So the first thing that you can see, because it got a little screwed up though, but we just really want to make sure that it's clear that Title VI applies to public schools. So we are talking about public schools almost the whole time during this webinar, but we're happy to discuss private schools separately, but this is about recipients of public funding. So Jen, you want to do a Title VI overview, and then I have a slide that sort of breaks down these three things a little more. Sharon, is that helpful?
I think that's great.
Okay.
Yeah, so when we talk about Title VI, I feel like a little bit compelled to say this, which is that people love Title VI. And I think that it's very powerful. And Jen, I know you touched on this beforehand, but I think that Title VI is definitely like a term of art that people use all the time. It just wouldn't be my first go-to. Okay. I think your school has lots of policies in place and lots of room for discussion before we file a Title VI complaint. But that being said, when you look at Title VI, you need proof of a hostile environment based on a protected category. So in this case, when we're looking at it, it has like particular categories that we're looking at, and that the administration had knowledge of the hostile environment. What does that mean, knowledge? That means that they like knew that it happened. When we look at actually Title IX, if you looked at Title IX under the Biden administration and you looked at Title IX under now the Trump administration, that knowledge factor or knowledge criteria changed. So under the Biden administration, it was you should have known or should have known. Under the Trump administration, it's actual knowledge. So recognizing and finding situations where we can demonstrate like this is what they knew is helpful, and that they had indifference or inaction. Okay, one of the ways in which you can show indifference or inaction is like the tolling of time, like not doing anything, like, okay, we'll get to that, or can you file this form, or can you do this? So that's a way in which you can show that you're not having that responsiveness.
Yeah. And I think that goes back to your point that you do have to do some work ahead of, really thinking about using this to put them on notice, to try to resolve it and to try to get them to do the right thing. And this is sort of that last resort where you would come call Jenna or Jen or another attorney and actually think about whether this is a tool to use. But I do think it comes up a lot. And am I right that the consequences, in the grand scheme of thing, although I don't know if it happens very often, it would be loss of federal funding, although the likelihood that that actually happens is pretty low, right?
Yeah, so I can tell you, like in my career, like I've you don't end up there because no one wants to be there, and so you
Right.
find ways to do remedial action or other options. There's been a couple cases where school districts have said fine, and it never comes to fruition, but that's usually not the place that you actually end up. Although at the post-secondary level, it looks like that's actually might happen.
Right.
Yeah, and we're not seeing that in the K through 12 space. And we have a bunch of, I should say, Stand With Us brings Title VI's against school districts. Sometimes it takes us a long time to build a case. So if someone comes to us and says, I have a great Title VI against a school district, we're talking about months when I'm working with them to make sure that all three of these pieces were met, right? Like exactly how severe and pervasive, how is it limiting or denying a student access to their education? What did the notice look like? If a parent says, I called the principal or I emailed the principal, I might say, okay, it's sort of constructive, but I'd love the actual notice. Let's file a formal complaint, right? And then the indifference or inaction piece, like it takes time. We can't say this thing happened on Tuesday and on Wednesday nothing was fixed. We need to give the school district some amount of time, but also it's not forever. So if a school district says we responded to it, there's great case law that basically says like, even though you held your assembly and you came out with a new program and you talked to this kid and you disciplined this other one, literally nothing changed. Right after a few months, that's like sort of when I say, okay, let's keep exploring this option. But to actually bring the Title VI, it takes a long time, first of all, to bring it. And then the federal government has a huge backlog right now of these cases. It's what I say to parents is it's a great option if nothing else will work. But it's not going to make immediate change at all. Some districts are sensitive to the bad press that comes with us bringing a Title VI, but ultimately, in a Title VI, most of what we see is that there's some kind of settlement agreement between the federal government and the school district. If you can get those things, those provisions from a settlement agreement fixed, like taken care of outside of a Title VI, I would do it that way, which is why it's so important. I think we're supposed to say this at the very beginning to like engage appropriately with your school district if you actually want to have a collaborative relationship, because you'll just end up there eventually. So maybe.
Yeah. So we're going to jump to practical steps in a second, but there's a great question in here, and it may be on other people's minds. It's certainly on mine, which is, I thought Trump was shutting down the Department of Education, so I guess OCR goes away. What then?
So there have been segues to a reduction in both OCR and the Department of Ed. Okay, so there are sections of OCR, like deployment sections, like in the city of Chicago or in other areas where the staff has been riffed or reduced in force or let go. So we have seen reductions in that. But I wouldn't pause on your personal efforts to help your kid based on a concern that the Department of Ed is going to go away. I think that is like a large philosophical question that I definitely understand the anxiety over. But I think that for all practical purposes, nothing is going away tomorrow. No systems are flying out the door immediately. And so I would really continue to look at the guidance, continue to see them as an option, as an avenue, because I don't think that worrying about the status of the Department of Ed is going to help like a particular case that you may have.
Yeah.
And I would just add that even if it did, which we'll see, there's still the Department of Justice, which has its own civil rights office, which we've actually had some really good interactions with them, helping us on some school districts. And there's also your state, which has a lot of responsibility as well, that also has its own civil rights or whatever they're going to call it office. So,
and am I right that this would really be a last resort, but you can actually bring a lawsuit under Title VI as opposed to going the administrative route, or am I crazy?
Go ahead, Jen.
You're not wrong, but in any of those areas, whether it's the EEOC or Title VI, there's exhaustion requirements, and I would not necessarily recommend that. I don't know, Jenna, if you want to add more detail to that, but.
No, I think that's helpful.
The egregious facts that have been used in Title VI lawsuits. I hope that none of us have to, like, it's pretty egregious if there's a lawsuit that we read about, and then there's usually other laws that are being used in that lawsuit. It wouldn't just be Title VI.
Yeah, I think that's super
So
helpful.
yes, I know parents really want to know about lawsuits. It's a last resort. The facts have to be pretty egregious. Like, we would have to really get into it, but it's not the first place we go, and litigation is terrible. So
it is, and it creates a lot of PR. And the other question I'm going to put in the parking lot, but I get a lot, is can I sue anonymously, or can I be anonymous? So we'll put that in the parking lot, but it's one that I hear a lot as well. So we've got 6 minutes. We probably could
go ahead.
The
parking lot, the anonymous question, I would just say, look at the policy, okay? Because certain policies do allow for anonymous complaints and others don't. So I would just refer that family back to their particular policies.
Beautiful.
And by the way, if you do, sorry, and I know you don't want to talk about this, now we're living in the parking lot.
No, you're great. Go.
If you just administrative complaints, or like a uniform complaint or grievance procedure, you can often make anonymous complaints, and then they won't be able to interview you, and the investigation will be limited. So it's an option, especially if you have real concerns. But like, let's talk about that and how we can help you with that. Stand With Us actually can shield families' identities in lawsuits and in some of these complaints, and I'm happy to talk more about that.
That's amazing. I mean, that's a resource we could probably, talk about for another day on how to do that. I think that's great to know. I think this will go into really the practical steps. And unfortunately, we only have a few more minutes. We could probably go on for days, like I said, but let's talk about practical, how to approach this, and best ways to really get the result you want, which is hopefully not suing, but to get protecting your kid.
A few things. And Jen, jump in at any point. We often, when we do a formal Know Your Rights training for parents, is we say, like, the first thing is just assume good intention. Treat people with respect, use thoughtful language, right? Like, there's a honey and vinegar analogy here. So that's number one. When parents have come to me, it means everything has already fallen apart. So I get to see like the worst possible versions of emails that parents send to school districts. And I can say, like, a lot goes wrong early on when we are rightfully upset and feel protective of our students and scared about something or triggered. We still should be careful. Again, if the goal is to collaborate with our school district and make real change, thinking about how to best express it. And I think one of the mistakes that I see a lot of is parents using this kind of legal jargon because they think that's going to get the school district's attention. I think it's better to use parent language. Like, if you want legal jargon, come to me. But the school districts want to hear from you about what's actually going on. What is happening to your kid? What are they missing out on, right? What club did they drop out of? What test did they fail? Like, when did they leave early? When did they stay home because they were scared? Those are the things school districts want to hear. They don't want you to do a thorough Title VI or First Amendment analysis for them, okay? Do not cry wolf. We talked about that, I think. Like, be selective in what you're doing, because at some point, right, like when I tell my kids to clean their rooms, they don't hear me anymore, apparently, because I say it so often. So let's be careful. Using thoughtful language matters for a few reasons. One is because it's a good thing to do, but also because when we use language that is not careful enough, it can be used against us. We get lots of stories from school districts of like other parents or the teacher coming in and saying they're trying to silence me. And if we go back and read the email from the parent, that is what they said they were trying to do, even if it wasn't what they meant to do. I know I'm going quickly, but I'm looking at the clock. And then the last is when we communicate to school districts, we say this to students, but also to parents. It's not so much about the intent of the person, right? So I know we're not going to talk about keffiyehs right now, but I often use it as an example. If somebody's wearing a keffiyeh in your classroom, it's a student, a teacher, a board member, whatever, don't worry about their intent. That has nothing to do with it, right? They might be wearing this, whatever it is, for a very beautiful reason. The question is, what is the impact that it's having on you? That is what you should be speaking to your school district about, and never really about what that person intends, unless you know what they intend.
Yeah. And really where I would build off of that is like kind of two high level points. One is sit down, sit back, and define what your complaint is. What we find often is that a lot of people complain. Okay, there are very lengthy emails with lots of complaining. But what we need to do is look at that complaint, and the complaint would be based off of exactly what Jenna talked about in terms of like what access was denied. right? What did the kid either not get to do, not get to do as much, or had to drop out of? So really identifying what your complaint is and how that complaint like manifests itself. And then the second is, I think it's always helpful to think of systems rather than people. Okay, so it's not about getting like Jen Deutsch fired, but creating a system by which Jen Deutsch has to follow certain rules or make certain restorative action. So I think that a lot of times what we find is that someone will come in and say, I want this person fired. I want that person out of a job. And I think that we'll be a lot more effective and have better outcomes if we're not just thinking about firing me particularly, but thinking about a system that really provides for like a safe and equitable education system.
I love the way you frame that, Jen, because I've been thinking a lot about that too, that sometimes if the district lacks certain policies or the laws don't exist to essentially allow the school district to do the right thing, it can seem like they're taking sides when they do a particular action. And so sometimes making sure that the controversial topics policies or their neutrality, whatever, allows them to say, I'm not taking a side on this. This is just our rule. And that's sort of what you mean by systems. Like if the systems are in place to allow them, you assume that regardless of the intent of any one individual, that the system will support a safe environment for the kids. And so I love the way you frame that. So thank you. I know there's some important steps we could take. We're right at 1 o'clock.
It's fine, Sharon. I'm just so parents can
yeah,
just take a picture of this now. Like people should just take a picture of this one, which is sort of the meat, I think. So apologies. And then the other one that I wanted to just, I'll leave that up on the screen for a second. Jen and I are happy to talk about it more. And then this is the other one that I, again, sorry for the graphics, but there's all kinds of reasons to report things that are going on. One is to make sure that you have a thought partner as you're going through this. So we have the red button that you can click on our website to report. It will eventually come to me. Reporting real concerns to the FBI and ADL matters for a few reasons, but also for data, right? So we all read those articles about how there's a spike in this or a spike in that. The numbers matter, and they won't know it if you don't share it. So that's there too. And then I can do this just if you want.
Amazing. Yeah, we didn't quite get to all the questions. I will capture them, and then we can always follow up with individuals. My favorite one is there CLE? And I just want to answer, I wish. For those of you non-lawyers, that's our continuing legal education obligations, and it's pretty onerous no matter kind of wherever you are. But really, thank you. I learned a lot already, and I'm sure our parents did. We will, if you need to reach out to me, I'm at Sharon@NAVIvalues.org. And then I will also make sure to pass on any questions to Jenna and Jen. We will have a primer coming out so that you can make more references. Reach out. And like I mentioned too, NAVI is working on a bunch of different policy initiatives, including institutional neutrality, curriculum transparency that Jen mentioned. Some states have it, some states don't. So we're happy to help you both on the policy side, the legal side, the advocacy side. We're excited and by being able to do this for our parents. For any specific legal issues, don't solve it yourself. Call a lawyer. Make sure that you get the right advice before you start invoking legal issues. And any other wrap-up points you guys want to make? I am just so grateful for your time, really.
I would tell the CLE looker that we have Stand With Us as a conference in Las Vegas in March, and there's a whole CLE day. So come.
Maybe
yes, come. And no, please check our website for tons of fact sheets and know your right stuff. And you always can email me.
And we'll share those out as well.
Thank you.
Jen, anything from you before we wrap up?
No, I'd just encourage everyone to continue what they're doing and know that as a parent, you are just like your kid's best advocate.
Yes. Thank you so much.
Thanks for doing this, Sharon.
Have a great day.
Thanks, everyone. Bye.
Bye.